Welcome. I'm Chuck Boyce with CV Creative. I can't even talk today. But today's edition of Tuesday Pulse is going to be talking about AI compliance. And I said that without panic because I don't want to be panic inducing. This is not a legal lecture. It's talking about compliance and what's happening in the marketplace right now. It's a grounded conversation about what matters today because it is a confusing market right now in what you can be liable for if you use AI. So this is AI compliance, again, without a panic. And here's what things you should take into consideration in 2026 to avoid trouble without hiring a lawyer. You don't need expensive software. You don't have to lose sleep at night. This is based for companies 1 to 30 employees who are using AI tools, even if you're just using ChatGPT to draft emails or summarize documents. If AI is in your business, this does apply to you because if it has any impact to your clients, it has impact on you. And so hopefully we can get a clear picture of what the regulators are actually looking at and some governance toolkits that you can build in a few hours. There's two resources that I'll give you, two forms, templates that you can use to fill out your own. And again, these are not legal documents. They're just one page or multi-page policies in my case. But let's set the expectations again. This is now a highly regulated industry, and there's a lot of changes that have happened, especially with the feds moving out of governing and putting it down to the states and the impact of doing business in one state and your clients in another state and which rules you have to follow. So here's what I want to cover today. What matters right now. First, the compliance landscape shift dramatically in 2025 because the Biden administration had set guidelines at a national level, and the Trump administration said that they're not going to the FTC is not going to enforce these, and they're putting it down to the state level. So if you've been putting off and waiting for clarity, it's just going to get a little more cloudy because as more states introduce guidelines, there's more things that you have to be aware of. So two most common mistakes that people make when they're trying to they're either overreacting or they're underreacting. There are strategies to go in the middle of the road, and we'll see how to do that. What the regulators are actually watching, there's four specific enforcement categories. They're not vague, and you'll see where the risk sits. Next, I want to talk about the toolkit, the 6 components. You can build them in under an hour. They're the heart of the session. I'll go through them. And then last, we'll just do a live review of the documents and show you what you need to do. And again, this is something you could do in half a day or less. So before we begin, again, what I said, I have 2 policy templates. One is what you need to be able to supply your clients if they ask for it, or a regulator if you get into some sort of legal issue. They just give you a defensible argument about your posture, knowing that you did think about it, you do have some ideas or some policies in place. Again, they're not legal, but if somebody asks for them, at least you're thinking about them and you can show that you've made a plausible effort to protect yourself. And the other one is your marketing claims. This is something that if you say that you're doing something with AI and you're going to save them tons of time, or if you're just parroting your vendor that you're using their state, if you don't have anything to prove what you're saying, the FTC would be on your case if somebody brings that up to the FTC. So be aware of any marketing claims that you make if you use AI in any part of your business. So the real thing is that it got very confusing. Enforcement is no longer theoretical. It's happening. And there are law cases that are actively being enforced right now, and people are getting fined many thousands or up to millions of dollars for things that they didn't take into consideration. And so this will hopefully help you reduce your risk. And so in January of this year, the federal AI safety executive order that Biden had signed, Trump revoked it. And so they thought that, great, no more pressure. We don't have to worry about this. But it's wrong and dangerous because it became more difficult because now it's at the state level. So the patchwork is there. If you operate across state lines, that means you're selling to an online client in other states. You're now subject to multiple state laws. There's not one clear federal standard. So if you're in Colorado and you're dealing with Colorado rules, but if your client is in Illinois, you now have to follow Illinois rules, and Virginia, Kentucky, California, Nevada, everybody is coming up with their own rules in different guidelines, different parts of what they want to protect, and it's getting very confusing. In the EU, if you're doing anything in Europe, then in August of 2026, in a few months, they're going to have a completely different one. A client in Germany making an online purchase can affect how you do it. It's not a European problem. It's that you have a European customer. And so there's even going to be more regulatory things that you have to be aware of. And so let's see where states are. So in Colorado, in February, 3 weeks ago, it required documented cases against algorithmic discrimination in 4 areas. So if you're dealing with housing, employment, credit, and insurance decisions, if you're using AI to screen job applicants, if you're setting pricing or services, if you're evaluating credit, if you're making recommendation in any of those areas, that applies to you. It doesn't care if you're a 500-person company or a 5-person company. If you're dealing with any of those 4 areas and you're making claims and using AI, it affects you. Illinois, they amended their Human Rights Act with specifically addressing AI in HR, human resources, any employment descriptions. It says that if you're screening resumes, filtering applicants, generating interview questions, if you're using anywhere in your pipeline AI, then Illinois law requires transparency and documentation. In both Virginia and Kentucky, both states have parallel employment AI disclosure laws that are active now. They require you to disclose when AI plays a role in workforce decisions, whether it's in hiring, promoting, or terminating. If you operate in those states, hire people, and AI is involved, you're involved. So the laws don't just apply to companies headquartered there, they apply to any decisions for the residents of those states, and those residents can come back to you, even if you're not active in that state other than your client is. And so if you hire somebody in Illinois, Illinois law applies. So you can't ignore this because you're too small. It's not a defensible position. The laws don't care about your size, they care about your behavior. So it's not just at the state level. There are some federal enforcements, but they're more with the FTC and not necessarily an overall AI policy, but they are enforcing AI washing, which is where you're saying that your AI is doing something that may not be. You may say that you're using AI to do something and there's really no AI involved. So there's a company called Clio. Clio AI paid $17 million in March of last year for misleading AI capability. They told consumers their AI could do things it demonstrably could not do. The FTC called that deceptive marketing under Section 5 of the FTC Act and applies to every business in the United States regardless of size. So in April, there were 3 cases. One company called Profit was fined for making false AI claims. And they're not Fortune 500 targets. These are companies that exaggerated what AI could do, and they got caught. So the FTC is not auditing your models. They're auditing your marketing claims. So if your website says AI powered, and they ask you to explain what it is, and you cannot explain what AI powered means, that means you're deceiving the client. So that's what any small business, if you're claiming that AI is in your business, the FTC says that you have to be able to explain exactly what AI is doing. And so the enforcement isn't theoretical. These are public cases, the fines are real. And so if you look at your website right now, any of your marketing materials, any of the emails that you send out, anything you put on social media, if it has the word AI in there and you can't back up what you're saying about AI, you may be liable for some FTC fines. So now here's the two modes of failure that most businesses are trying to adjust to. It's either ignore it, we're too small. It was just ChatGPT, that's not really AI. Nobody in our industry is doing this, and we'll deal with it when somebody makes us. And so that's failure mode one. The FTC says that any business making a claim is liable to back that claim. It's deceptive marketing if your website says AI powered and you can't substantiate the claim with evidence. So again, doesn't matter your size. It could be huge. You could be a single employer, a single operator. Again, the Clio case wasn't against a giant. It was still a $17 million claim that said that they could do AI and they couldn't prove it. So, do you have an AI policy? And again, it doesn't have to be a full legal document. You just have to be prepared. If you're unprepared and say, we'll ignore it until we need to do it, you're too late. The other one is over-investing. So this is where you say, oh my gosh, we need to settle this now. We need to spend $30,000 on compliance software designed for a big corporation when you only have a few employees. So it doesn't make it safer, it just makes you slower. And so this is when it says, oh, we need an enterprise compliance, or we need to wait until the law settles before we act, or our lawyer, our attorney hasn't told us what to do yet. All of those are just excuses. If you're waiting, again, you just need a relatively simple solution to show that you are taking the initiative to protect and inform your clients. So, minimal viable governance. You've probably heard of minimal viable products or minimal viable formulas, but this is governance. And so you're not building a huge compliance thing. You're just doing the smallest version that works. You're implementing documented, reviewable, defensible posture that is proportional to your actual risk. And so if a client, a regulator, or a cyber insurer, again, now you're talking about insurance because some businesses will need cyber insurance. And so if they ask, what's your AI governance policy or posture, you have to be able to hand them something, a document, a process, a log, something that says, yes, we thought about this. Here's what we do. That's your minimal viable governance. It's not perfect. It's not exhaustive, but it's honest, documented, and more or less defensible. And so businesses that freeze are in trouble, businesses that ignore it are in trouble, but businesses that build a simple, honest system are more protected. You still may have some sort of fine, but at least you put the effort in to show that you are making that effort. So the safe middle road. So what are they actually looking for? They're not auditing what tools you're using. They're not saying, oh, because you're using Anthropic or you're using OpenAI. It's your behavior of how you're communicating that and what you're actually saying. That's what the FTC is looking for. So the four categories that they're active right now, they have fines, enforcement actions, state legislation. None of them require you to be a technology company. You don't have to be an AI vendor or anything. You're just saying that you're using AI in some form or less in your business. And this could just be in your marketing. So, number one, AI washing. Falsely labeling a product as AI when it isn't, or overstating what your AI does. Again, multiple cases since April of 2025. If your sales deck, if your proposals, your website, anything that you're doing mentions AI, you need a compliance list to back up what you're doing. Category two is automated decisions affecting people. So, as I mentioned, hiring, lending, housing, insurance. If you're using job screening, if you're doing lead filters, if you're doing pricing, any recommendations that affect an individual. If you're in Colorado, Virginia, Illinois, possibly other states coming up, you do have to document the rationale behind every automated decision. Number three is your data collection. If you're collecting anything like biometric data without clear consent, if it's just a photo, if it's photos now, they can, I don't know if you've seen the Super Bowl commercial with the Ring talking about finding lost dogs. Put a picture of your dog up on there, and Ring will find a picture of the dog and say, oh, yeah, we saw it over here. But what they didn't say is that people could put photos of people. And so if this person walks by and captured on your Ring cam, you could now track them. And so there's all sorts of weird things that with data collection, just weirdness around that. So anything with voice recordings, facial recognition, behavioral tracking, anything that captures that, consent is required. The last one is vendor pass-through risk. And this is where the vendor makes the claim and then you repeat it. And you didn't validate that vendor claim, but you're saying that, then you are the one saying it. It doesn't matter if the vendor did. If you put their claim without proof in a proposal, on your website, in a pitch, it's your liability, not the vendor's. And so make sure that you capture the vendor's statement in documentation, and then you can use that. And so let's go a little bit deeper on that one. And so AI washing, again, is exactly what it sounds. You say that you overstate what AI does. If you make a claim, you have to be able to substantiate it. It's just documentation. If there's test results, if there's vendor evidence, if you can't produce anything, that's not doing enough and you're liable. So you're deceptive. And so if we say our platform uses cutting edge AI to optimize your workflow, and you can't actually explain what that does, that's AI washing. And so don't do that. The other one is the vendor pass-through, as I mentioned. If the vendor claims that AI can predict customer churn with 95% accuracy, you think, wow, that's impressive. Let's put that in my sales deck. And then your client says, show me the data. If you can't prove that and show that proof, you have that liability. You're lying. And so the FTC does not care for that. So if you make a claim, you own it. Doesn't matter where you got that claim from. So write it into your policy. The same thing, anytime you mention AI in any client communications, be able to back it up. Automated decisions. Here is where you're screening job applicants, or you're filtering sales leads, or you're doing pricing services. Any of these states that have those laws right now, they're not that difficult to find, but you do need to be aware of them. And so if you can explain why AI made the recommendation, not just that it made one. So an interesting case was with an employment agency that went to an applicant screening software that was AI formed, and one of the rules were to screen out applicants who were more susceptible to long-term medical leave. And so that AI decided to wipe out any female from 18 to 40 who would be possibly be pregnant. And so that's a long-term medical issue according to AI. And so it knocked all the women of birth age out of their policy, which again was a bad thing to do. So as long as you can understand what it's doing, it's not producing discriminatory outcomes. If you're using AI to price your quotes, you need to be able to explain the pricing logic if they ask for it. Data collection, same thing. Whatever you collect, biometric data, whether it's voice, facial recognition, behavioral tracking. If you're using AI to record that, to use chatbots, you have to get consent from the people involved. So if you're collecting data, if you're steering it, you're making decisions based on what the AI is saying, all you have to do is disclose that. Be able to prove what it's doing and the theory behind it. Again, simple documentation, but you do need that documentation. So the minimum viable governance kit, 6 components, it's not long. You can do this in less than a day, an afternoon, a morning, whenever you want to do it. So Here's what you need to follow. Your approved list. Which tools are approved for what tasks and by whom? And then, better yet, what data can and cannot go into the tools. Time to build 30 minutes for each of those. Find out which tools you're using, which tools your employees are using. There's a lot of shadow AI involved where you may not even be aware that some of your employees are using a certain chat bot, whether it's ChatGPT or Claude or something like that, and they're using it to build something that they're presenting to a client. If you're, as a manager, an owner, a supervisor, not aware of this, they're going against you, and it may be putting data into an AI tool that you're not aware of. Even though your employee is doing it, you as a business owner is responsible for that. The data disclosure is tell your clients what you're using AI for, when you're using it, and how it's used. Vendor claims, make sure that anytime you want to repeat what the vendor claims as your own marketing materials, make sure that they supply you information that backs up their claims so you can back up your claim. If you do have AI and you're using it, make sure that you keep logs of any errors, data issues, complaints from customers, what was the resolution, how it was fixed, or if it was fixed. Again, a simple log doesn't have to be superly detailed, but is showing your effort to track any errors, issues, and complaints. And then do this on a quarterly basis. And so the longest step is going to be your initial. Once you do that on a quarterly basis, it's going to be a much less time consuming process. But again, do this quarterly. So here are your components, your approved list. This is a simple, just have the tool name, your approved task, and what the prohibited uses are. So if ChatGPT is approved for drafting communications and summarizing documents, it's not approved for inputting client financial data or PII or personally identifiable information. That's one row, done. Do that for every AI tool you have. If someone's using Claude, Perplexity, Gemini, Grammarly, Veed, any tool that you're using, if it uses AI, document it. Then you have to figure out who your AI lead is in your company. And you should have an AI guru and a hero, a champion, whatever you want to call that, but somebody responsible for everything around AI. That'll be something that you really need to do. But again, just simple documentation. Data rules are even simpler. You classify what you actually handle. If it's client PII, financial records, health information, employee records, if the data would embarrass you in a breach, then make sure that it's protected. So again, if you're worried about it leaking out, don't put it into AI. If you have a data processing agreement, a DPA from a vendor, that means if you're using them to store any of this secure data, you need to get a data processing agreement from the vendor. And so whatever vendor you're using and you're storing customer data that handles PII or financial records, whatever, you need to get a DPA from them. Again, back it up, delete it when you ask, notify you if there's a breach, anything that they affects your client data, you have to be aware of and have that agreement from them. And so for every tool on your approved list, see if you can get a DPA from the vendor, and if they can't provide you, flag the tool, at least you're flagging it, and that's all you have to do. Again, 30 minutes, talk about the disclosure posture. And so you don't need to disclose every use, but you do need to be accurate. If you mention AI in your marketing, proposals, websites, pitch decks, it has to be substantiated. Again, means that you can explain what AI is doing and have evidence of how it's working. If AI makes a decision that affects a customer, that could be a price quote, a product recommendation, an approval or a denial. if you can disclose the state laws of California or Colorado, Illinois, and Virginia, disclosures are part of how you have to do business. And so just have a simple, clear one sentence on your website, your proposal footer, your client onboarding documents. Just say that my company uses AI assisted tools to enhance efficiency and quality in whatever function. All AI outputs are reviewed by qualified staff to deliver before delivery to clients, and any decisions remain under human oversight. And so a quick, simple sentence that's specific, defensible, takes less than an hour to draft this and put it into your standard documents, put it on your website, whatever, just make people aware that you do use AI, and if they come back, be able to supply it with additional documentation. So next would be your incident log. Just keep simple spreadsheet with a date, the tool, what happened, who's effective, and what was done to resolve it, if anything was done or if you're still working on it. It doesn't have to be complex. 15 minutes, if that, put in a Google spreadsheet, put it in an Excel file, whatever. The easiest way that you can do this, make it happen. And then, again, as I mentioned, do this on a quarterly basis. The first run you do of these is going to take a little bit longer, but on a quarterly basis, it could take you less than a half an hour every quarter. And so that's your entire system. That will protect you in many ways. So here, let's just go through the documents that I will show you here. So the review, very simple. Here is a policy. You just put your organization, review dates, your purpose. And so here again is approved tools and uses. ChatGPT, drafting communications, who's approved it, and where it can't be used. Do this for every single tool. Here, your classification of data, if it's public, internal, or sensitive. What requirements are there? Do you have DPAs? Do you have prohibited vendor terms in your training materials, or how do you train your your models? However, these are the things that you have to disclose, be documented. Your disclosure posture, when AI is mentioned in your marketing, it contributes to automated decisions if it's required by law. Just have a simple statement like, we use AI assisted to enhance, as I mentioned earlier. You don't want to claim that AI capabilities have not been personally verified, or results in accuracy levels cannot be substantiated. You don't have to say it, you just have to say that you use AI and be able to back things up. Standard marketing have to be specific. You can't just say that we have AI-powered solutions. You have to say that we do AI for such and such and be able to demonstrate what it does. And again, vendor pass-through, you have to verify that the vendor's claims are valid before you can make those claims. Incident reporting, any of the following rules must be followed. Here's your incident log location. For training and requirements, make sure that any of your staff that uses AI signs off on everything, all your policies, what they're using, what it can't be used for. Make sure that you have signatures from each of the employees that is possibly using it. Quarterly review. Again, this doesn't have to be a very long document, but depending on what you want to be covered, it can be longer. This is, I said, a 1 page, but this is a 5 page here. Next is the marketing claims. This is more of an interesting one because you have to have any claim, you have to be able to say specifically what it is, not just AI powered. You have to, if you repeat the vendor claims, as I said, you have to be honest. It doesn't have to be in depth, just honest. Your transparency has to be there. If anything about pricing or screening or recommendations, if you used AI, just say that you used AI to do this. It doesn't have to be in depth. AI driven, AI powered, doesn't cut it. So with this marketing claims checklist, again, very simple, the purpose. Can we describe what AI does beyond AI powered? pass-fail notes. Very simple, just yes or no. Does every mention of AI correspond to a tool or process? Can we name it and demonstrate it? Do we avoid cutting-edge AI or advanced algorithms without explaining what they actually do? If we claim AI learns or adapts, can we show evidence that that happens? Yes or no? Again, if you say no, you may have a note to say why it's no, but at least you're hitting that claim that could come up in any sort of inquiry by a regulator. And so, just simple terms, you have to be able to substantiate them. And so here's the test. For every AI capability, do we have documentation, test results, vendor evidence? Can we claim AI improves accuracy, speed, or quality? Those are test results. Yes or no. You don't necessarily have to be able to prove it, but if you say no, it's documented. We have avoided claiming results because we have not personally validated things. Can we cite vendor performance claims? Can the vendor substantiate them? Yes or no, just simple questions. Your honesty about limitations. Do you disclose that AI requires a review? Is that true or not? Do we imply that AI autonomously acts autonomously if humans are actually involved in the decisions? If humans are involved, let them know. Don't just say that this is all AI. If it doesn't, if it is all AI, say yes or no, but at least document it. Don't claim AI eliminates error, bias, or judgment. If you make any of those claims, make sure you can prove it. If you're saying that AI has known limitations and you're not disclosing it, does it have language support different data types? Have you looked at various edge cases? Just acknowledge them. Don't overstate it. Just have you thought about this? Your vendor passed through, we talked about, have you independently verified their claims? Have they provided you documentation to be able to verify their claims? Do you have documentation from them? Have you confirmed that they provide model cards, test reports, transparency documentation? You may need all this stuff. It may seem like overkill, but you're protecting yourself because, again, if a client is in a state that has those laws, they can ask you for this information. And if you can't supply it, then they could possibly report you to the FTC or the state regulators. If AI contributes to automated decisions, yes or no? Do we have AI in lending, hiring, screening? Yes or no? Do we have claiming that AI is personalized service when it's actually generating? So if you're saying it's human, but the AI is doing it, yes or no? Again, very simple questions to go through. This will take you 30 minutes to an hour to go through. Change control. Have we reviewed our claims in the last 90 days? Do we change tools? Have you updated your documentation to document that you've changed tools? Just as simple as changing from ChatGPT to Claude. Do you have it documented that you made that change? And you don't have to say why you made the change, but just show that you did make the change at a certain time. Removing all claims that you cannot justify. Is there a clear owner? And this is one where a lot of people have problems with, is that you have to have an owner assigned. If it's the owner of the business, if it's the operations manager, if it's your sales manager, somebody has to be responsible for these decisions. Score them, see what your pass fail is. If you have 0 to 4 fails, you're at low risk. You address flagged items within 30 days. If you have moderate risk, immediately review. But if you're in high risk, pause all marketing claims until you've corrected and reviewed, maybe with an attorney. So just fix your common problems. If it's AI-powered platform, give it more detail. If it's vendor claims, make sure the vendor can support it. If it's performance claims, make sure that you have backing data. If it's claiming full automation, make sure that you can prove that. So whatever you say, just make sure you can back it up. Here's your next steps. Who's it done by? Once this is done, you store it on a Google Drive. It's always accessible. You make sure your staff knows where these documents are kept, and then you're going to be in better shape. So in the next 30 days, what you need to do is audit all of your tools and start creating a spreadsheet of what tools what it can be used for, what it can't be used for, and who's the owner of those tools. Next is to apply your rules, flag all your sensitive inputs, find out what your marketing is, find out how the performance, how your guidelines, how your human interaction, document that, and then go through your marketing materials. Make sure all your marketing is making valid claims and can be backed up and documented, and then all you have to do is draft your one-page policies. Pretty simple and straightforward. And so the next questions are not too basic. If you're thinking, what if my AI vendor is making one of those claims? It doesn't matter. If you pass that claim on, you are making the claim. And so if you're not sure about what the vendor is claiming and you can't prove it, don't repeat it. We're a service building business, and we don't use AI, or we don't build AI tools. It does apply to you if you use AI in your marketing, if you use AI in any part of building your business, pricing, making recommendations, any part of that, disclose it. What about clients who want to prove that we're compliant? Give them the documentation. Simple documents. Again, just if you have any questions about this, feel free to set up a 30-minute call. I can walk you through all this stuff. Pretty straightforward, but the more documentation you have, the more, or the safer you are, the less risk you have. Even with the documentation, there's a chance that you get a angry customer who just wants to rile things up and said that you want to challenge the claims you make about AI, and they have a heavily regulated state that they live in, and they're citing one regulation in that state. You have to be able to counter it. And so just be prepared. That's really all we need to do, is show the effort and show that you've documented things. And so I'm going to stop the share, and I'm going to stop the record.